very happy to be here today. I'm Kathy Paciullo. I'm the president and CEO of the Kenmore-Tonawanda Chamber of Commerce. And we are just very excited. Several years we've been doing this with Harder, Seacrest, and Emery. So this is the 2024 Labor Law and Employment update, employment law also. And we have Anna McCarthy and Chloe Macdonald, two of the attorneys, and they are ready to give a great presentation. So if I haven't caught up with you to mute your mic, please do that yourself, and we will enjoy some time and have this great information again available to you. This is being recorded and it will be available at a later date also if you need to catch anything and get any refreshers. Thanks and good morning. I'll throw it over to you guys. Now you have to unmute. You got too many mutes going on here.
I think, Chloe, you might still be muted, maybe. I think I'm unmuted.
There we see here. I got the phone number. Let me just try to unmute. No.
Okay, can you all hear me now?
That's terrific. Yes, thank you.
All right, thank you very much. I'm sorry for that little technological issue. So Anna, if you wouldn't mind flipping to the slide with our headshots on it, thank you. Just to put a face to the name. Hello, good afternoon, everyone. And as you're joining, if everyone could please mute, that would be most appreciated. So good afternoon. Thank you for joining us today for the webinar. And thank you, Kathy, for the introduction. As you mentioned, my name is Chloe Macdonald. I am here with my co-presenter, Anna McCarthy. We are both attorneys at Harder, Seacrest, and Emery in the firm's Labor and Employment Practice Group. Anna and I have worked together for like 8.5 years now, and hopefully some of our friendship will come across in this presentation today. We'd like to thank the Kenton Chamber of Commerce for having us and hosting today's webinar. As Kathy mentioned, we've done this for a couple of years. We really enjoy doing this for all of you. Before we get into the content, and we do have quite a bit to cover, a few housekeeping items. This webinar has been approved for 1 credit of HRCI and SHRM credit, and we will give instructions on how to submit that at the end of the presentation. We'll have the code. Also, please know that this webinar is intended for general information purposes only and should not be considered legal advice. Please keep your lines on mute during the presentation. If you have questions, you could submit them using the chat feature. Depending on timing and what the questions are, Anna and I will do our best to address them either during the presentation as they come in or during a Q&A at the end, again, depending on timing. And with that, let's get started. So here is our agenda for today, and you might be thinking, geez, Chloe, that is a lot of bullet points. How are you going to get through all of that? And some of them are going to be really quick updates that we can jump through. We are going to focus on New York updates, but you'll see we also have a few federal updates as well. I think some of the federal updates are the most interesting, and they're ones that Anna is going to cover. So stay tuned for that. We'll jump right in to our first set of updates, which are wage and hour updates. We're going to start with the wage and hour updates. Wage and hour is one of the driest areas of employment law, so we're going to get it out of the way right at the beginning. So our first slide here discusses increases to the New York State minimum wage. I'm sure we are all aware that the state minimum wage increased in January of 2024. We are in June. If you were unaware for the past 6 months, time to get on top of that. So I want to draw your attention to the bottom of the slide, which talks about planned updates or increases to the minimum wage, in January of 2025 and January of 2026. We are at that perfect mid-year point where we want to start thinking about next year's payroll expenses. And so be aware that these minimum wage increases are on the horizon. like I said, we're going to keep it moving. So I'm going to go to the next wage and hour update. So this update is with respect to salary threshold increases for exempt employees. I'm going to back up a little bit. Certain employees who have certain job duties can be exempt from overtime requirements under federal and state laws, right? We know most employees, we have to track their hours, we have to pay them time and a half for overtime. But if they are an exempt administrative, executive, or professional employee, the EAP employees, as the Department of Labor calls them, they can be exempt from overtime requirements if they make a minimum salary. New York State has salary thresholds for administrative and executive employees. In 2024, that number increased to $1,124.20 per week. Don't forget the 20 cents per week. And this is the majority of the state.
I am, and then I heard people talking, and now all of a sudden nobody's talking, but people are still.
All right, are we good? Anna, can you hear me?
Yeah, I think we're good.
Okay. So, again, look at the asterisk. These rates apply to generally New York State, but downstate has higher rates. We're focusing on upstate rates because that's where we're located. So there was an update or an increase in 2024 to the minimum salary for executive and administrative employees in New York State. Be aware that there are also planned increases in 2025 and 2026. So right now, with the current increase that equates out to about $58,000 and change per year, being the kind of yearly salary threshold. In 2025, the number is set to go up to $1,161 per week. And then in 2026, it's set to go up again to $1,199 per week. So be aware that those changes are coming, and those will impact your administrative and executive employees. Again, I would please ask, as you're joining the call, to just go on mute. Thank you so much. New York State does not have a exempt salary threshold for professional.
All right, we did lose you, and I'm not sure why. Yep, the phone. So can you just unmute yourself on your computer?
Hi, am I back?
I think you're back, yeah.
Okay, great. What I think is happening, Kathy, is that I think you might be muting everyone, and it's catching my phone as part of the kind of muting everyone as things are going. So
I was trying not to do that. So
but
what is the last what is the last four of your phone number?
7665.
Okay.
All right, thank you.
I've left that alone. Sorry about that.
All good.
Yeah.
Okay. So I was speaking about the federal minimum threshold increases for professional employees. There is no New York State minimum. And so we have to turn to the federal threshold for our professional employees. That number is set to go up. It has not gone up in quite a while. As of right now, it is $684 per week. As of July 1st, so really right around the corner, that minimum salary threshold is expected to go up to $844 a week. There are pending legal challenges to this rule. I was double checking them last night. I did not see any legal decisions coming out on this one way or another. My greatest hope is that they have not come out in a short amount of time that I haven't checked today. I certainly don't want to make it a liar out of me, but keep an eye on that, because it's certainly possible that there might be a successful legal challenge to this rule. But as of right now, plan for that salary threshold to go up and for it to impact professional employees. Okay, moving to our next wage and hour update. And you might be thinking, Chloe, this is also about salary threshold increases for exempt employees. Didn't we just talk about that? This is slightly different, right? Because we like to keep things complicated over here in wage and hour law. So in New York State, exempt administrative, professional, and executive employees that make a certain salary, in addition to being exempt from overtime requirements, are also exempt from certain frequency and method of pay laws under the New York State labor law. However, in order to be exempt from those laws, those employees have to make a minimum salary. And this salary is different than the minimum salary for overtime exemptions. On the last slide, we talked about the minimum salary being $1,124,000 or something to that effect. Under this exemption, it has to be at least $1,300 per week. These frequency of pay laws have to do with when you pay employees, right? For most employees, that would be biweekly or semi-monthly. If you have manual workers, weekly. Commission salespeople, it could be a month. But there is an exemption available for these laws if they are an exempt administrative, professional, and executive employee, and they make at least $1,300 per week. All right, moving through these wage updates because they are pretty quick. This is the last quasi wage update that I want to touch on today, and it has to do with wage theft. In September of 2023, there was an update to the New York State penal law, and wage theft was added as a type of larceny. Wage theft is now defined in the penal law as when a person, which could be a business, owner of a business, obtains property by wage theft when he agrees to hire a person to perform services, and the person performs such services, and then the defendant withholds wages from that person. So essentially not paying employees wages is now a form of larceny under the penal law. Interestingly, in the prosecution of these cases, the amount can be aggregated. And what does that mean? Well, we can look at all the wages that have been taken from a particular employee, or we can look at all the wages that have been taken from an entire workforce. And when you aggregate those numbers, you get above $1,000. That is a felony level offense. This can be pretty serious. Now, there were previously criminal penalties available under the New York State labor law for wage theft, but by adding it into the penal law and making these amendments, it has allowed for more serious felony charges for wage theft. So just something to be extra cautious about. You might be thinking, this can't possibly happen. Why do we even have to go over this? Of course, we're paying our employees, but there already have been cases, specifically one in New York City that hit the news with a family-owned pizza shop where the owners did wind up pleading guilty to larceny via wage theft. So some pretty serious charges to be aware of. And with that, I will turn it over to Anna to discuss the Pregnant Workers Fairness Act.
Thank you. Okay, so yeah, this is the first thing I'll be talking about. Thanks, Chloe. So the big highlight here, and you may have seen some news about the Pregnant Workers Fairness Act, is that the regulations that implement this act just went into effect last week. To sort of get it out of the way, this applies to employers with 15 or more employees, generally speaking. So if you're very small, if you've just got a handful of employees, it's not going to be directly impacting you. It doesn't mean that these issues aren't important and they aren't things that you need to be aware of as a smaller employer. New York State treats these issues in a similar way, but the actual requirements of the act are only going to be applicable, generally speaking, to those employers with 15 or more employees. So the next few slides are going to go through some of the highlights of the PWFA and its implementing regulations. So the actual act was passed last year. So it's technically been in effect now for about a year now. Actually, I think it might be a year tomorrow. And so the requirements, the basic requirements of the act have been in effect, but the real important thing that I just mentioned is that the regulations that the EEOC have published to implement the act only went into effect last week, and they're pretty extensive. The actual document itself is about 130 or so pages. The regulations are much shorter, but there's a lot of interpretive guidance that employers should be aware of to interpret the regulations and to figure out how to be in compliance with the PWFA. So at a baseline requirement, this act is intended to accommodate the physical or mental conditions related to, affected by, or arising out of pregnancy, childbirth, or any related medical condition. And that's broadly interpreted under the regulations by the EEOC. This was born out of a court case. The EEOC sort of explained in implementing these regulations, their aim was to address a court case that at this point, I think is probably about 10 years old or so. The case is called Young v. UPS, and it was about a UPS driver who became pregnant and was unable to then lift heavy packages during her route, her UPS route, during her pregnancy. So as a response to her inability to lift those heavy packages, UPS forced her to take unpaid leave during her pregnancy. And then as a result of that unpaid leave, she eventually lost her medical coverage. She gave birth and then actually went back to her job eventually. She did bring a court case. It moved very slowly, as court cases tend to do, through the legal system. Eventually, it did result in her being made whole, but it took years. And the EEOC also separately investigated UPS's pregnancy accommodations policies. There was a big multi-million-dollar settlement related to that. But the EEOC, again, in implementing these regulations, was trying to address this particular situation. So the issue here was, yes, this person was eventually made whole, but it took her years, and she lost the job security that the EEOC feels pregnant people should be entitled to if they have a job, and that pregnancy shouldn't be the reason why they lose job security or the security of insurance or whatever it is. So the PWFA is intended to provide simpler, faster accommodations for a working mother and their family. Importantly, it doesn't cover bonding or childcare, even though it does cover some postpartum medical conditions like post-birth complications and related issues related to lactation. But if you're thinking about bonding time or childcare issues for your employees, that's going to be the FMLA, New York State paid family leave, even New York State paid sick leave, or a PTO policy if you have one. So this is specifically pregnancy and accommodations related to medical conditions. So I mentioned the regulations were effective as of last week, the 18th, for almost everyone with 15 or more employees, except for people in Mississippi and Louisiana. The portion of the regulations related to accommodations for elective abortions, that portion of it is not effective in those two states based on a recent court case. And then there's also a related court case in Texas from a few months ago that put these regulations on hold for state agencies in Texas. But putting that all aside, if you hear anything about court cases, it's likely not going to apply to you because for everybody else, as long as you have 15 or more employees, the regulations are in effect in full. Just briefly, this is related to the Americans with Disabilities Act. So you're probably already familiar with the ADA if you have 15 or more employees. That law is intended to provide accommodations for people with disabilities. This is similar, but again, it's meant to target, obviously, specifically pregnant people and conditions related to pregnancy, but it's also intended to provide faster, simpler accommodations than the ADA. The process is a little bit faster. There are more restrictions on the employer. So there are some similarities, but you'll probably want to think about updating your accommodations processes potentially to ensure that they also are compliant with the PWFA. I'll talk about a big difference between the ADA and the PWFA in a second. So the baseline requirement, again, it's accommodations for people related to their pregnancy, childbirth, or related medical condition. Importantly, a big difference from the ADA, so a big difference from your normal accommodations process for people with disabilities, is that an employee is still entitled to an accommodation under the PWFA if they're unable to perform all of the essential functions of their job, as long as that inability is for a temporary period of time. So under the ADA, to be qualified to receive an accommodation, you have to be able to perform the essential functions of your job with or without an accommodation. Under the PWFA, a temporary inability to perform an essential function of your job does not disqualify you from receiving an accommodation. So a really simple example, it's a very basic example. Say you have someone who works in a supermarket at a fish counter, and an essential function of their job is they have to work with fish all day. There's really nothing else that somebody working behind the fish counter is doing. You know, maybe they could be cleaning up and not working with fish, but they're still behind the fish counter. Someone who's pregnant may have an aversion to the smell of fish. The inability to work behind the fish counter during your pregnancy because of the fact that you have an aversion to a fish smell and it's making you ill does not disqualify you from an accommodation. So an employer, unless it would cause an undue hardship, has to find a way around that. So maybe it's moving you to a different job for a period of time. Maybe it's you know, finding. I'm not really sure what other accommodation you could use in that instance, because it's sort of all encompassing. You really can't work in that location. But unless it would pose an undue hardship for the employer, you have to accommodate that employee, probably by moving them to a different location in the store. The conditions that are covered are wide ranging. It covers the gamut from fertility treatments before you're pregnant all the way up through postpartum conditions. Maybe a condition that was exacerbated by being pregnant. And again, this requirement to accommodate exists unless it would pose an undue hardship to the employer. And the bar for showing that it's an undue hardship, or showing that you would face an undue hardship, is pretty high. Just a few more things to be aware of before we move on to our next topic. You have to engage in the interactive process, what's called the interactive process, with somebody who requests an accommodation. So if an employee is requesting an accommodation, you have to engage in a back and forth. It can be informal, it doesn't have to be by email, it doesn't have to be verbal, it can be however it works out with your employee. Some sort of interactive dialogue to come to an accommodation. So you have to basically work with your employee. You can't just say, okay, well, you're telling me you're pregnant, this is the accommodation you have to have. This is the accommodation I'm willing to give you, and we're not having a conversation about it. You have to engage in a back and forth with the employee, and do that before you arrive at an accommodation. Ultimately, the choice of accommodation that is up to the employer's discretion, but you need to engage with the employee before you make a decision to ensure that you're taking into account their preference and the information that they're providing to you. Just want to remind everybody to keep yourselves on mute so that you're not speaking over either myself or Chloe. So anyway, that's it in a nutshell. There's a lot more out there, but we have so many other updates that we want to get through that we're going to move on to the other updates. But that's it in a nutshell to be aware of for now. So relatedly, there are a couple of New York State-based updates that are related to pregnancy or pregnancy-related conditions. The first one is paid lactation breaks. This just went into effect last week, effective as of the 19th. So as a New York State employer, you're probably already aware of the fact that New York State requires you to accommodate people who need to pump breast milk during the workday. Up until last week, those breaks could be unpaid. And now, as of last week, employers have to provide employees with 30 minutes of paid break time each time an employee has a reasonable need to pump breast milk. So that could be maybe upwards of an hour and a half, maybe even 2 hours of paid break time, depending on how long somebody's workday is. You also have to allow an employee to use their existing regularly scheduled breaks, whether an unpaid meal break or a paid unpaid rest break, for lactation purposes. But it's not either or. You have to provide the 30 minutes every time they have a need to pump breast milk, in addition to allowing them to use their existing break time. So this is definitely a change. Also, just a heads up that the state created policy that you currently are required to pass out to all of your employees at hire and annually, and when somebody returns after the birth of a child, that has been updated with this change in the law. So download that policy from New York State's website and make sure that you're replacing it with the previous state created policy that you had to distribute. And then the final related state update is prenatal leave. This is not effective yet, But as of January 1st, employees are going to be entitled to a bucket of 20 hours to apply to prenatal issues. And this can include regular routine medical appointments related to somebody's pregnancy. It's not for the partner or spouse of someone who's pregnant. This is for the actual pregnant person to take leave, paid leave, to take care of prenatal issues, including those routine medical appointments during someone's pregnancy. Leave can be taken in hourly increments, and there's no requirement to pay this leave out upon separation. This is part of the paid sick leave statute, but there's nothing right now that definitively tells us whether or not you can use your existing PTO policy to cover this requirement. So for now, we're treating this as a separate bucket of time, but we're also awaiting guidance from the Department of Labor. So we'll see what happens with that. So I know that was kind of a fast overview of sort of pregnancy and pregnancy related updates. The highlights are, if you have 15 or more employees, be aware of the Pregnant Workers Fairness Act. For everybody in New York State, be aware that lactation breaks now must be paid. And then keep an eye out on the horizon for the January 1 start date for this new bucket of prenatal leave. And I'm going to pass it on to Chloe for our next update.
Great, thanks, Anna. I think that's one of our most interesting topics of today. So much interesting and upcoming stuff there. All right, a federal update here with respect to the non-compete ban. You may have heard about this in the news because I think it really made quite a splash. So the FTC issued a rule that as of right now is set to go into effect on September 4th of 2024 that prohibits employers from entering into or enforcing non-compete agreements in most circumstances. It's important to distinguish between non-competes and non-solicits. I see the two get confused often in my practice. A non-compete is an agreement where an employee says they will not work in a certain field, presumably within a specific geographic area, for a certain amount of time. A non-solicit, which I see more commonly in my practice, is an agreement that one will not go out and poach clients or take clients that they worked with at their former employee for a set amount of time. This ban is specific to non-compete agreements, which are already disfavored by New York State courts. They are not banned, but they are generally disfavored. There are some exceptions to the FTC's ban, which are notable. The first is for senior executives. These would be policymakers at a company, right? High-level employees with decision-making and policy-making authority that are making at least $151,000 and some change a year. Those employees can be subject to non-compete agreements. Another exception is for non-compete agreements that are entered into as a part of a sale of a business. Those are still permitted. Employers are also permitted to continue to enforce a non-compete that's already in litigation. So you had a non-compete agreement with an employee, they left, they violated, the employer sued them. That litigation can continue. It is not mooted by the FTC rule. Employers will be required to provide notice to impacted workers that they will not be enforcing non-competes against them. So right now, as we're leading up to the effective date of this ban, think twice before you enter into a new non-compete, because do you want to have to give this sort of notice in just a few short months? Now, there are some pending lawsuits that could impact the ban. There are lawsuits currently pending in the Northern District of Texas and the Eastern District of Pennsylvania. They are currently both deciding preliminary injunctions that could stay the effective date of this rule. The Texas court decision is expected by July 3rd, so just around the corner. Look out for news of that. And the Pennsylvania court decision is expected later this month. When we're thinking about the non-compete ban, what should employers be considering? First, watch out for those court decisions that I just mentioned. To the extent you have non-compete agreements, you'll want to be aware if you need to give that notice to employees that they will or will not be effective in the future. And also, with this ban on the horizon and just general trends in the law, I would review your current restrictive covenants and assess their terms. Maybe you've got an agreement that an attorney drafted for you like 10, 15, even 5 years ago that you just pull out of your filing cabinet every time you hire an employee into a certain position, now is a good time to review that, make sure that it's not in violation of this ban, assuming it takes effect, and also just get a sense of if it's current and up to date with New York State's general trend towards non-solicits versus non-competes. All right, and I will turn it back to Anna.
Thanks. Okay, so we're jumping around a bit, but there's been a real range of updates recently, both on the federal and the state level, as you saw from our kind of extensive agenda list. So the next federal-based update, which has been sort of the talk of the labor world over the last year or so, relates to two Supreme Court cases that were decided last year: Students for Fair Admissions v. Harvard and Students for Fair Admissions v. UNC. So these cases were big. They made a big splash, mainly because of the way that people interpreted them and sort of foresaw or used them to foreshadow what would come next. Ultimately, the actual holdings of these cases with respect to diversity, inclusion, and equity developments are pretty limited. So as your run-of-the-mill private employer, it doesn't actually directly affect you. But we've seen a lot of fallout from these cases that does directly affect private employers of all sizes. So it's an important thing to be aware of and to keep your thumb on in terms of the changing climate around DEI initiatives, whether it's hiring initiatives, training initiatives, programs you have in your workplace. Maybe you have employee resource groups. Maybe you have a scholarship program. There's a lot of different ways that people have implemented DEI efforts in their workplace. And it's a good thing to be aware of. So in terms of the legal takeaways from these two cases, the Harvard UNC cases, for private employers who do not receive federal Title VI funding, this does not apply to you. It doesn't directly apply to private employers. This decision was specific to the schools' affirmative action programs and schools specifically that receive Title VI funding. There was even a suggestion in the, or more than a suggestion, there was even some language in the decision that exempted military academies. So this was a fairly narrow holding when you're talking about the entire, employment industry, the entire workforce of this country. The other thing that it didn't do was affect any Title VII or related federal regulations or orders based on race-based employment decisions. Race-based employment decisions are still illegal under Title VII and related federal regulations, and that continues to remain the case for and after this Supreme Court case. The other thing that has continued to remain the law of the land are voluntary affirmative action programs under Title VII. So on both sides of the spectrum, discriminating on the basis of race and any other protected category was before and after this decision illegal, and voluntary affirmative action programs before and after this case are legal under Title VII and its implementing regulations and the EEOC guidance. What has changed is how these programs are implemented and how initiatives should be approached. So the current issues right now, and there are many, I've highlighted some here. One is that the EEOC is kind of mixed on what to do with employers' DEI efforts. So we've gotten some differing opinions from the EEOC board related to what to do with this. We also have seen that private employers have been the target of test cases challenging DEI initiatives. So an example in the legal industry has been that large law firms tend to have clerkship programs. Some of these clerkship programs for law students were focused on giving scholarships to minority students specifically. And we saw a couple of big law firms be targeted for their scholarship efforts because of the fact that the scholarship was restricted to minority law students only for these particular scholarships. So we saw them be the focus of these cases. Now, in both cases that I'm thinking of, the cases ended early and there was no decision on the merits because the law firms decided just to change the language of their scholarship program rather than to fight the case. So we didn't get a legal holding out of that to know exactly what to do in the private employment sphere. The other thing that's still an issue is that traditional discrimination lawsuits are still a risk. So where we see some employers sort of swinging hard to the other side, getting rid of their DEI initiatives because they don't want to be the target of test cases. They don't want to be called out for reverse discrimination. We see people swinging too hard to the other side and removing those initiatives altogether, forgetting that traditional discrimination lawsuits are still a risk. So it's going to be, and there are really no clear answers in this sphere. It's very much case by case. But the real takeaway is you just need to think more critically about your DEI initiatives. If you've implemented DEI initiatives in your workplace, or if you're thinking about hiring a workforce that looks more like the community that you live in. So things to think about from sort of a broad standpoint are making sure that, let's say it's a hiring initiative, making sure it's based on hard data and business related criteria, and that you're not saying, let's fill a quota. We need a certain number of people that, fit this race-based criteria. That race-based criteria and quotas have not been acceptable for decades. So doing something as blatant as that is not okay. What you should do is focus on initiatives that achieve your goals without following a quota system or specifically race-based criteria. So whether that's thinking creatively about how to expand your candidate pool, maybe recruiting in new areas, maybe joining a job fair you've never joined before in a different community, or maybe it's advertising for your job placements in other areas that you haven't advertised in before. It's thinking creatively in those ways to maybe broaden your candidate pool, expand your hiring practices, that you can get at creating a diverse, inclusive workforce in other ways other than a specific quota system, which again hasn't been legal for decades, but this sort of shone a light on that in particular. The other thing to keep in mind is that you need to continuously reevaluate processes. If you have hiring initiatives in place that are intended to create a more diverse and inclusive workforce, or you have specific training programs intended to train and diversify your workforce, make sure you're checking in to see how effective those programs are. If they're not achieving the goals that you want to see, reevaluate them, rethink them. That's the best way to sort of stay ahead of any legal issues, is making sure that you're not letting any of your hiring initiatives, your training initiatives, your employment practices get stale. So like I said, no real clear answers. And this is probably a bit of a frustrating portion of the presentation because I can't give you any clear answers, but they should be things that you should be thinking about no matter how big or small you are as an employer, because it's certainly an issue that's not going away. And that's being continuously highlighted, whether through court cases or guidance. And I'm going to pass it on to Chloe to talk about something that's semi-related to hiring initiatives.
Thanks, Anna. I'm going to talk about the Clean Slate Act, deals with background checks, which is an area that I do a lot of work in and really enjoy talking about. So New York State passed the Clean Slate Act. It is set to go into effect on November 16th, 2024, and the Clean Slate Act automatically seals certain criminal convictions after a period of time. Misdemeanors are, in most cases, going to be sealed 3 years after the date that incarceration is completed, and felonies will be sealed 8 years after the date of the completion of incarceration. So 3 years for misdemeanors, 8 years for felonies. If there is no incarceration, let's say you're convicted of a misdemeanor and you're sentenced to a year probation, the clock will start running from the date that the sentence is imposed. That's how we're going to keep this clock running. A few exceptions to automatic sealing that are notable: Class A felonies are not subject to sealing. If there is a subsequent conviction, that will restart the clock. So let's say I was convicted of a misdemeanor 2 years ago. I become convicted of another misdemeanor. Well, that 3-year period that maybe I had 1 year left on, that clock is now restarting to 3 years, and neither of those convictions is going to be sealed until a full 3 years passes. Similarly, a conviction cannot be sealed if there are pending charges or if the individual is on probation or parole. So if there is a pending charge when that 3-year or 8-year clock runs, we're going to continue to push sealing until either that pending charge is resolved in the individual's favor, or if there's a subsequent conviction, then that clock will start to run all over again. So why do employers care about a change to the criminal procedure law that allows for automatic sealing? Well, there are some definitive impacts on employers. First of all, the New York State Human Rights Law was revised to prohibit discrimination against individuals with convictions sealed pursuant to the Clean Slate Act. So now it is part of the Human Rights Law that once this takes effect, you can't hold a sealed conviction against an employee or a candidate. Relatedly, a sealed conviction cannot be held against an employer as evidence in a negligent hiring case. And this is consistent with laws that have been in effect for a long time that say if you do the conviction analysis required by Article 23A of the correction law and you make the determination to hire somebody based on their convictions, that again cannot be used against the employer as evidence of negligent hiring. There's also some notice requirements that are worth talking about. If an entity is searching criminal records for civil purposes, which could include employment, they must give the individual whose records are being searched a copy of criminal history information, a copy of Article 23 of the correction law, which is the law that establishes that analysis of convictions that employers should be doing. And then they also have to give the individual information on their right to seek correction of any incorrect information on the report. So maybe the individual thinks, geez, this conviction should be sealed under this law. You have to give that person notice and information on how to do that. I am hopeful that we will get additional guidance and regulations on this. Maybe, fingers crossed, even a sample notice that could be provided in the future. Again, the effective date is not for a couple of days, and so I wouldn't expect that to, or a couple of days, couple of months, my goodness. I would not expect for that guidance to come out much closer to the effective date. The Office of Court Administration will have 3 years from the effective date to seal all impacted convictions. They are supposed to be starting now, but technically they will have until November of 2027 to complete the sealing process. So there will be a little bit of a limbo period while they go through all of the old records. Consideration for employers. First one, which is the one that gives me the most anxiety when it comes to this particular law, is the Google beware issue, right? You know, we meet somebody. I was at a networking event yesterday. I met some people. The first thing I did when I got home was Google them, right? And employers might be inclined to do that with a candidate or an employee as well. But if you Google a candidate and you find information about a felony conviction that was 15 years ago, there is probably a good chance that conviction is now sealed and that you are now prohibited from considering that sealed conviction when you're looking at making a hiring decision for that individual. So employers should be very careful about what they pull off the internet about candidates and make sure that they're kind of taking that out of their background check process, right? Use a reputable background check provider. Don't necessarily rely on a Google article to tell you about a conviction from a long time ago. If you ask about past convictions in the interview and you're not in an area covered by a ban the box law, or if you have employees fill out questionnaires related to past convictions, take a look at those, make sure that you're specifically instructing them to not disclose convictions that have been sealed, things like that to make sure that you're not getting information that you cannot lawfully use. And if you are an employer who runs your own criminal history searches, think about those notice requirements and develop a process for getting that information out to candidates if you are running your own searches. If you are running your searches through a background check provider, touch base with your provider to make sure that they are on top of this Clean Slate Act. They absolutely should be, and that they are providing all of the required notices if that's something that you've engaged them to do for you. All right. Moving on to social media protections, this law took effect in March of 2024, so a few months ago, and it covers all private and public employers. And under this law, employers cannot request, require, or coerce its employees to disclose their personal social media account authentication information. So you can't ask an employee to provide their username and password so you can log into their Facebook or Instagram. You cannot require employees to access their personal accounts in the presence of the employer. So, hey, I want to see what you're posting on your Instagram. Show me right now, right? No good. You cannot require employees to reproduce information from their personal accounts. So send you a screenshot or something of that nature showing what's on their social media account. And you also can't take adverse action against somebody who refuses to do one of those things I just discussed, right? So essentially, you can't ask them to do that. And if you do it and they say no, you also can't retaliate against them for that. This covers only social media accounts that employees are using for personal purposes. It does not cover business accounts that your employees may be running for you, right? So maybe you have somebody in your marketing department that is running your business Facebook page. Of course, you can require access to that account. Employers can require employees to disclose information on their internal system. So let's say somebody is saving something on their work laptop or in your file share system, whatever that might be. Of course, you as the owner of that system have access to it. We already talked about business accounts. Yes, you can require them to provide access to those accounts as long as the employee was provided with prior notice of that. You can access a device that you as the employer pay for, again, if the employee was provided notice and the employee agreed to that, right? So we don't want to surprise employees with these requests down the line. That notice component is important. You can comply with court orders. You can continue to have your restricted websites, and you can obtain information that is voluntarily shared. This is very important, right? So if an employee comes to you and says, oh my gosh, can you believe what somebody just posted, and they show you it, that would be voluntarily shared. That would be okay to consider. You can also consider information that is publicly available. So if somebody has a not private page, that would be an exception to this. So some considerations for employers. Number one, have a policy, have a protocol for business accounts and internal systems. I actually run into some issues of this with clients that I work with where they have employees kind of going rogue and creating their own business related Facebook pages, and then the employee leaves and nobody can get access to it. Have a policy that prohibits that, right? That requires people to have permission to create those accounts, and that requires that usernames, passwords, access information be shared. Consider using specific policies and written acknowledgments to memorialize agreements. A couple of those things above require notice, right? Notice about access to a device that the employer paid for example. That might be a good place to have a written acknowledgement showing that that notice would be given. And the last one is really interesting. Be careful about how you conduct internal investigations. I would say it, in some cases, and probably on a more frequent basis as time goes on, employees may engage in conduct over social media that is concerning, or maybe that comes up in a harassment complaint or a discrimination complaint in the workplace. So be thoughtful about these social media protections when you are conducting investigations that involve social media. Again, you are allowed to obtain information that's voluntarily shared or publicly available, but you can't force people, you can't twist their arms to share something that they don't want to share from a personal Facebook page. Make sure you incorporate that concept into your internal investigation process. All right, back to you, Anna.
Okay, I'm going to keep this portion of the presentation hopefully down to a minute or two. The highlight of the next two slides is this is your annual update or annual reminder that the harassment and discrimination laws are ever changing. I feel like every year there's a new either federal or state update. The good news here is that this new EEOC guidance that was issued in April, effective immediately, April 29th, 2024, first update in EEOC harassment guidance since 1999, really is, and I'm generalizing here, kind of nothing new for New York State employers, because our harassment laws, our anti-harassment and anti-discrimination laws are pretty extensive, and in a lot of cases already covered this area. So if you're already compliant with New York State law, then the guidance here is really going to be nothing new. Some of the highlights include the fact that include reminders that intra-class harassment, so someone in the same protected category as another person can still be engaging in harassment on the basis of that protected category. So an older person can be harassing another older person for their age, even though they're both older. Harassment based upon association is a thing. So harassing someone because of their relationship with someone else who is a part of a protected category or protected class. There was a focus on the fact that technology has become a huge issue. So remote working environments do not take away the ability to harass somebody else. In fact, it may increase it because you've got more avenues of communication between coworkers. Another highlight is that there was another recent Supreme Court case from this year that lowered the bar to show that discrimination has occurred. So that is going to mean for employers that cases are going to get farther through litigation. The bar has been lowered for employees to show that unlawful discrimination has occurred in the workplace. And then just to note that effective a few months ago, New York State has now extended the statute of limitations for claims of unlawful discrimination or harassment on the basis of any protected category. People now have 3 years to file a claim versus the old standard, which was 1. And I'm going to pass it back to Chloe. Oh, Chloe, I think you may have.
Okay, this one's going to be super quick. Super quick. I wanted to go so fast I didn't even take myself off mute. Okay, unemployment insurance notices. As of November of 2023, you must notify employees of their right to file for unemployment by using the New York State DOL specific form that is available at that link. That is the big change. Make sure that link document is part of your process. Use that notice. Okay, moving on. All right, this update is related to intellectual property rights. There's a New York State labor law section that went into effect in September of 2023. Under this law, employers cannot require employees to assign rights to their inventions that are developed by the employee on their own time without use of the employer's equipment, supplies, or facilities. Employers can still require employees to assign inventions that relate to the employer's business or that result from any work performed by the employee for the employer, right? So those are those kind of exceptions, and that usually is what an IP assignment agreement covers. Takeaway here, similar to the non-compete, look at the agreement that you have. If you haven't had it updated recently, make sure that it is in compliance with this law and not requiring employees to assign anything that they're not allowed to assign under this new law. All right, back to you, Anna.
So our last 2 updates also have to do with agreements with your workers or your employees. In this case, the Freelance Isn't Free Act would be agreements with people providing services to you who are not your employees. So if you engage with independent contractors or freelancers, this is applicable to you. Any contracts entered into on or after August 28th of this year, so it's coming up, need to follow certain requirements. If you're familiar already with the New York City Freelance Isn't Free Act, this is going to feel very familiar. But if you're not in New York City, if you don't have employees down there, then this is going to be new. Essentially, it's a list of best practices for what already probably should have been in your independent contractor agreements if you're contracting with independent contractors. So the highlights are that if you are entering into an agreement with an independent contractor, you need to have certain things in there, like an itemized accounting of the services they're providing for you, the rate of pay, the payment date, and you also have to make sure you're paying within 30 days of the completion of said services. There's also some anti-discrimination and retaliation penalty or provisions built in, and there are some pretty steep monetary penalties as well. The big takeaway here, though, is that this law does not save you from a misclassification issue. So just because this act exists doesn't mean you have a free pass to enter into an agreement with anybody and call them an independent contractor. They need to actually meet the definition of what an independent contractor is under New York state law. So this is a bigger issue for another day, but the bottom line is there is a line between who's an employee and who's an independent contractor. And you need to be careful about not crossing that line with the people that you're engaging with. So the takeaway is, if you've got independent contractors, this law, the effective date is coming up, and you need to make sure your agreements are in compliance with the requirements. Last update is also related to agreements. So this law related to non-disclosure agreements has been in effect already in New York State, but there were some recent amendments that you should be aware of. The previous requirement was that you couldn't, as an employer, since I believe it was 2019, require confidentiality of the underlying facts of a sexual harassment or discrimination settlement unless confidentiality was the claimant's preference. So if you're entering into an agreement with, let's say, a former employee regarding their claim of sexual harassment, you can't require them to stay quiet about their allegations. This was a law that was passed in response to the Me Too movement. There were some recent updates that expand the provisions of this agreement, or rather provisions of this law, to now include independent contractors as well as employees, and to potentially include separation agreements. So if you've got, let's say, for example, you have an employee who filed an internal complaint of harassment. They internally complained about harassment at your workplace. And then for whatever reason, they end up being separated from your place of employment, and you enter into a separation agreement with them, which includes a release of claims, which is pretty typical if you have a separation agreement that you're giving consideration for in exchange for a release of claims. That would potentially fall under this law. And the new requirements prohibit provisions related to liquidated damages or forfeiture of consideration for a violation of a non-disclosure or non-disparagement clause. And it also prohibits affirmative statements that the complainant, the former employee, was not subject to unlawful discrimination, harassment, or retaliation. It's a bit of a complicated update. The bottom line is, as Chloe said a few times during this presentation, if you use a separation agreement, make sure that it's not old or stale or hasn't been updated in a number of years. You're going to want somebody to take a look at it to make sure that you're not running afoul of these requirements. So if you've got a standard separation agreement, talk to your counsel of choice and make sure that the provisions in that agreement are okay, because if not, the consequence is that your release of claims could be voided. And that's a pretty big consequence, because that's really what you're paying for in a separation agreement. So that wraps it up, and we're at 1 o'clock. So we don't want to hold anyone over, and we want to be respectful of people's time. So we don't have, and I actually don't know that I see any questions in the chat feature anyway, which is great. So we'll wrap it up here. I just want to say, oh, I should mention actually our HCRI and SHRM credit before I forget. So if you need HCRI or SHRM credit, the activity ID number is 671837. That's the HCRI credit. So again, HCRI credit is 671837, and the SHRM activity ID is 24-4E as in Edward, 62C as in Christopher. So the SHRM activity ID is 24-4E62C. So that's for SHRM and HCRI credit. I want to thank Kathy and the Kenton Chamber of Commerce for having us. We really appreciate the opportunity to talk with you all. As Kathy said, we've been doing this for a number of years now, and it's always great to be back to do a labor update. So thank you again to everyone for attending. Thank you to the Kenton Chamber for hosting. And I will just pop the activity codes into the chat feature so that everybody has them. And otherwise, that concludes our call. Thank you so much for joining us.